Hello, guys. So let's begin with the Unit 5, Legal Profession in India. The modern legal profession has colonial roots because everything began from the time when we were the colony of Britishers, right? Even the courts, the first courts were established, presidency towns or mayor courts, during the British era only. So, whatever we have, that is the colonial shackles. Emerging with Advent is arrival of mayors courts in Madras and Calcutta. These were the presidency towns and Bombay also, but mayor's court came up in these two places in 1726. It was not until 1846, that means 1726 से सिर्फ 1846 तक मेयर कोर्ट्स थे. The Legal Practitioners Act that doors of profession were thrown open to all those duly qualified, certified, good character, irrespective of nationality or religion. Women were still excluded from this profession to be thereafter admitted through the Legal Practitioners Women Act 1923. This is 23 of 1923 means in 1923 there may be a number of acts which were passed, number of legislations which were framed, and out of those whole list of legislations framed in 1923, this act was the 23rd of them. That means from this list of acts passed in 1923, this women act was in 23 number. That's why it is written 23 of 1923. Okay, so anywhere else also, if you find something written like IPC in bracket act this of 1860 और समथिंग लाइक दैट, ऐसे लिखा होता है हर जगह पे. सो दैट मीन्स कि उस ईयर में पास हुए जितने भी एक्ट्स थे उसमें से ये एक्ट इतने नंबर पे था. दिस वॉज द 23rd legislation or act which was framed or which was brought into force in this year. Fine, this is the meaning. Now, what it said that the Legal Practitioners Act, now earlier it has colonial roots, only the Britishers were the lawyers, only English law was applicable, and the English judges also, and they had appointed some priests, or for Muslim law some experts of the Muslim priest, right? So that in matters of personal law, because Britishers do not know the rules of religion, they only know what the Christianity says. They had no knowledge about Hinduism and Islam. So for that, if any matter comes to them, they will not be proper justice delivering because they couldn't understand and couldn't apply it properly. That's why they had appointed some experts, and experts were whom? The priest or the greater knowledge people belonging to those religions, right? And they could only suggest. Again, the application of that suggestion of the rule would depend upon the English judges only, and to fight the cases, that was also dependent upon the English lawyers. But from or since 1846, by the Legal Practitioners Act, the doors of profession, that means even other people who were duly qualified, who had the certificate, who had obtained a degree of law, and they had a good character, that means you can be trusted upon. It seems that you are an honest man and you can fight the case for welfare of the person, for the client, right? No matter to which nation or religion you belong. दैट मीन्स नाउ सिर्फ इंग्लिश लॉयर होंगे कोर्ट में, या उनका रिलीजन मेजरली तो क्रिश्चियनिटी ही होता था, उसके अलावा भी नाउ इट वॉज स्प्रेड टू अदर रिलीजन एंड अदर nationals. But still, we were not so advanced to allow women to enter into the profession, but they entered through 1923 Act. The legal profession in India includes both practice and professional legal education, which is regulated by the Advocates Act 1961. So, the legal profession is not only to practice the law. Practice the law means the lawyers who are fighting the case, who are practicing the law. That means they read the legislations or the acts which are framed by the legislature from time to time, whether it is a state legislature or the central legislature, right? IPC, CRPC, CPC, all these are what? Central legislations which are applicable throughout the country, right? But some states would have their own legislations on certain matters, of which jurisdiction is limited to that particular state only, like local laws, land revenue laws, rent act, ठीक है? सो वो सिर्फ उसी स्टेट पर लिमिटेड होता है. So they read, the lawyers or the judges, they read those laws, they interpret it, means try to get the meaning of the lines, of the language, of the expressions or statements which are written by the legislature, and to derive that what could be the intention of legislature by writing these expressions in the act, what it could mean, what was the purpose for which this act was, or this provision in that act was made, and then to apply that law onto the facts. Facts means the matter in dispute in a particular case that is in front of them, or with which they are dealing, right? For which they are fighting. जिस भी क्लाइंट के लिए लड़ रहे हैं उसका क्या मैटर है, उस पर कौन सा लॉ किस तरह से अप्लाई होना है, ठीक है? और उसके बाद आपको कैसे अपना केस कोर्ट में प्रेजेंट करना है अपने क्लाइंट के लिए, सो दैट द बेस्ट जस्टिस कैन बी डन टू योर क्लाइंट, right? And also the judges also have to hear to both the parties who have applied the law to the facts of the case, and then deliver the justice which is favorable or convenient as per the matter, right? So that is known as practice of law. हम सिर्फ लॉ को लिख दें उससे काम नहीं होगा, बट यू हैव टू इम्प्लीमेंट इट ऑल्सो. सो वो इम्प्लीमेंटेशन कैसे होगा? व्हेन द लॉयर्स दे रीड द लॉ, अंडरस्टैंड व्हाट इज रिटन, व्हाट इज द पर्पस, टू whom it is serving, राइट? इफ अ पॉलिसी इज मेड, जब तक समझ में नहीं आएगा कि वो पॉलिसी किसको रिसीव करनी है या किसके लिए बनी है, तो उन तक पहुंच नहीं पाएगी, right? If a policy is made for the betterment of like subsidies, cylinder subsidies या ये सब जो प्रोवाइड किया जा रहा है by the government, अगर वो उन तक पहुँचे ही ना, what is the benefit of making or framing such policies? So if the law is not implemented or received by the person for whom it was made, if the purpose is not achieved, then there is no benefit of making that law. So practice means to implement the law, and implementation is by applying it to the facts of the case which is in hand. And education also. So whatever we are doing right now, that is legal education, right? That all is regulated by the Advocates Act. Bar Council of India. Now since it is of India, that means it is at the central level. Envisaged under Advocates Act is a body for regulating minimum standards to be maintained by institutions imparting legal education in India. The Bar Council of India, bar means court. So the Bar Council is having the duty to regulate the basic और मिनिमम स्टैंडर्ड्स कि ये तो होने ही होने चाहिए, इससे ज़्यादा है इट इज़ वेरी गुड, बट इससे कम नहीं हो सकता, right? You cannot go beyond such standards. That is only the meaning of the minimum standards, right? So the minimum standards which are important to be maintained, and you cannot do away with these by the educational institutions in which any of the legal course is provided. The reformation of legal education undertaken since late 1980s at initiative of BCI, UGC, Law Commission and various state governments has led to the establishment of various national law schools in India in the last 2 decades. So now now not only the central universities or some private universities which are providing such legal education or legal courses, but we also have NLUs. These national law schools are basically known as NLU, National Law University. Fine. And right now we have more than 17. This movement, which was pioneered by Professor N.R. Madhav Menon, instrumental in setting up our first national law school in Bangalore. It is the first, it is the oldest and the topmost law school till today, NLSIU. And other leading academicians in India has resulted in establishment of around 17 NLUs and a few other in public and private sector. So private, that means private universities, right? India has the second largest population of lawyers in the world, second only to United States. That means first one is US and then we have India. Number of persons admitted to practice law has increased from about 70,000 in 1947 to 1.25 million in 2014. So number of persons admitted to practice law means lawyers or advocates. Their number is only increasing. History. 1726, later 1750, mayor's courts. No established legal profession until the establishment of mayor's courts. Because अगर कोर्ट नहीं होंगे तो जो नॉर्मल जैसे राजा या पंचायत में फैसला हो रहा है विलेज पंचायत में, या फिर राजा अपने जो दरबार होता था उसमें बुलाकर फैसला करें, बट एज सच दैट फॉर्मल एरिया ऑफ पब्लिक ऑफिस और कोर्ट वाज नॉट देयर. सो एज सच कोई लॉयर नहीं था. अगर राजा के दरबार में भी क्या होता था, कोई हिस्टोरिकल सीरियल अगर देखा हो कि पार्टीज खुद आती थी, अपना बताती थी कि साहब ऐसा ऐसा प्रॉब्लम है, इसने मेरे साथ ये किया, बट एज सच कोई ऐसा लॉयर नहीं था और उनको कोई लॉ नहीं पता था, कोई लॉ नहीं था, जो राजा बोल दे वही लॉ हो गया, राइट. सो जब लॉ बनने लगे, एक डॉक्यूमेंट्स में कोडिफाइड होने लगे, तब बात हुई कि नाउ यू हैव टू इम्प्लीमेंट दीज लॉज ओनली. इसके अलावा आप अपने मन से कुछ नहीं कर सकते, या अगर करना भी है दैट इज ओनली इन द केस व्हेन देयर इज नो लॉ ऑन दैट मैटर. दैट इज इक्विटी, राइट. इक्विटी or something that you can do in good faith because there is no law on a point. But other than that, you have to apply the laws which are made by the legislature. So when there was no court, there were no lawyers or no legal profession as such. Those who practiced law were devoid of legal training. So whosoever was practicing, whosoever was learning the acts and then implementing it, as such कोई legal training या legal course नहीं किया था उन्होंने. And some of the functionaries under the mayor courts were dismissed servants of British East India Company. And some of the officers in mayor courts were who? The dismissed servants means जिनको वहाँ से as servants हटा दिया गया. अब उनको कहीं ना कहीं से तो कुछ कमाना था, तो वो आकर, see that's why they were also devoid of any legal training. But उनको इधर से dismiss हुए, they need a job to sustain their families, so they now came into this profession. एक्ट पढ़ के थोड़ा पढ़ाई करो और यहाँ पर अप्लाई करो. दैट्स वाई दे वर नॉट हैविंग एनी लीगल ट्रेनिंग. जो आज होता है दैट इज़ प्रॉपर कोर्स किया आपने, सारे लॉज पढ़े, आपके कोर्स को टेस्ट किया, तब आपको BCI में एनरोल किया जाएगा एंड देन ओनली यू कैन एंटर द कोर्ट एंड प्रैक्टिस इट. दैट मीन्स यू कैन बी एन एडवोकेट, राइट. 1774 Supreme Court established by Royal Charter at Calcutta. See, this is the main things. पहले Supreme Court Calcutta में था. So, similar courts were established in Madras and Bombay. Regulating Act empowered Supreme Court to approve, admit, enroll advocates and attorneys at law. So, one homework that I am giving you, find out the meaning and difference of the term advocate and attorney. People use it interchangeably most of the times, but try to find out the difference between the two. And if you have done it, then comment down and let me know that whosoever has done my homework. The Regulating Act empowered Supreme Court to approve, admit and enroll. Means to approve that okay, this person is qualified, he has obtained a certificate of degree, okay, I am approving this person. I will admit or I will give admission to the person and I will write his name in the register of advocates, that is enroll, right. You when you get enrolled in a school, you may have some enrollment number with you, right. That's what the number of the number in which you are in that list of students of that school or university, right. Enrollment number diya jata hai har jagah, so that is enroll. Attorneys of record were authorized to appear, plead and act for the suitors. Appear means to come in the person, to come personally in the court. To plead means to fight the case, to present the facts and then as per this law, this is the remedy, this would be the best effective remedy for this party as per this situation, right. Attorneys were not admitted without a recommendation from high officials in England or a judge in India, and judges were also Britishers at that time, right? So attorneys were only admitted, they were only given admission if a high official in England or a judge of India has given the recommendation for his admission. तभी उनको attorney की तरह admit किया जाता था. Advocate at that time was extended only to English and Irish barristers and members of faculty of advocates in Scotland. Scotland is also a country in England, in UK, sorry, in UK, right? So the term advocate was only extended, or in the term advocate only those people came who were barristers in English and Irish part of UK, or the member of faculty of advocates in Scotland. UK is England plus Ireland plus Scotland. Now there is one more term which you have to find out about, that is barristers. Attorneys is similarly referred to British attorneys and solicitors only. Calcutta Supreme Court therefore appeared to be the exclusive bastion of British barristers, advocates, attorneys. So कौन था? Lawyers भी सिर्फ Britishers थे. That is what was written even above, that earlier the profession was not limited to many people, but then in 1846 it was thrown open to any person respective of nationality, right? So the same thing you can find, since we are talking about 1774, so till this time Supreme Court was only a place of barristers from English or England. 1793, the Bengal regulation created for the first time a regular legal profession in the company's courts. So regular legal profession means now it was considered as something which can be practiced regularly or throughout. Regulation was one for appointment of vakil or native pleaders in the courts of civil judicature, Sadar Diwani Adalat, in Bengal, Bihar and Odisha. Only Muslims and Hindus could be enrolled as pleaders. Pleaders means the person who pleads or who presents a case, right? So native pleaders means the local persons who can plead, which were only supposed to be belonging to these two religions. So now you see the other religions, apart from Christianity or apart from Britishers, now they had brought into the picture. The regulation provided for Wakalatnama in favor of a pleader, authorizing him to represent the party and act on his behalf in a matter. See, if you divide the term Wakalat plus Naam, okay, we say it Wakalatnama. That means there will be a document in which a person has written that he or she is my Vakil and I am giving the authority that he is representing me in this matter. Okay? So if I am appointing somebody as my agent or my representative to take decisions or to act on my behalf or to do any such thing which would be deemed that as if I myself have done it, so I have to give him that due authority or permission, no? And without my consent, he is not supposed to act, right? And I am also assured that whatever he will do, that will work in my benefit only. तो उतना ट्रस्ट रिलेशनशिप भी होना चाहिए between the lawyer and client. So वकालतनामा states that a particular person or vakil would be authorized to represent the party and act on his behalf in a particular case that is matter. This was the genesis of Wakalatnama as we know today. Even today, this is the same thing prevalent. The Bengal regulation of 1814 consolidated the law on the subject. Means it consolidated the law on this matter. The pleaders were empowered to act as arbitrators and give legal opinions on payment of fees. That is what even done today. But they are not actually arbitrators. They are not the one who will decide the dispute. So arbitrator is basically, I hope we have done the arbitration chapter, right? So what is in arbitration? That there will be a third neutral party who will give the suggestion or who will apply the law onto the case and give the decision on the basis of suggestion. He will try to concile or do conciliation between both the parties so that the matter can be resolved, right? So what is that? Because the layman or the parties to the suit, they may not know that what is a particular legal point on the issue or the dispute which they are having. So they will go to a person who has that knowledge, and that is who? The pleader, the lawyer, or some legal expert, right? So, and he will provide you that legal opinion which is required, but he will charge something. That is, you have to pay the due fees. Then only he will open his mouth and give you the advice, right? So not only giving of the legal opinions, but also to implement it in a manner that the matter is dissolved. That is the basis of, or the purpose of arbitration proceeding, which is done even today. In 1833, Bengal regulation modified the provisions of earlier regulations regarding selection, appointment, remuneration of these pleaders. So 1833, again a Bengal regulation was enacted, which modified, that is changed, the provisions of earlier regulation with respect to selecting, appointing the pleaders. Pleaders is advocates basically, or lawyers you can say. It permitted any qualified person of any nationality and religion to be enrolled in the Sadar Diwani Adalat. Diwani means basically related to civil matters. 1846, the Legal Practitioners Act was the first pan India means throughout India, law concerning the regulation of Indian legal profession. So, this is an important one liner. The first pan India law concerning regulation of Indian legal profession. This may be a question and the answer would be this. So you need to remember, not only for this class 12th exam but for in future also. A religious test for enrollment as a pleader was abolished. Religious test means whether you have the knowledge of that religion or not. Earlier Christians were the only pleaders, then Hindus and Muslims were also introduced. So why Hindus and Muslims? As I told you, because there may be some personal law matter on which that Christian judge is not well versed with, so he may need some experts belonging to that religion. So now you have that ample knowledge of religion or not. For that, this religious test was taken, and if you passed, then only you will be enrolled. That is obvious. So that test was abolished. Now the admissions could be purely on the basis of the educational qualification of the person, and person of any nationality, religion could be enrolled. Every barrister enrolled in any of Her Majesty's courts in India became eligible to plead in the Sadar Adalats, subject to the rules of those courts applicable to pleaders as regards language or any other matter. See, there may be some local language restraints, because you know in India every 10 kilometer the language changes, right, the vernacular or the local language of the people, it changes. So whatever the language constraints are there, or whatever the rules of the courts apply, in which those barristers were enrolled, apart from that, now every barrister who was enrolled in any of the court in India, he was eligible to plead in the Sadar Adalats. Sadar Adalat means the civil courts which were made. The Legal Practitioners Act also permitted wakils to enter into agreements with their clients for their fees for professional services. Now, why professional services? Because the legal or the practice of law emerged as a regular profession, right? So now whatever professional services they were providing to the clients, for that they can also enter into the agreements that I am representing you, I will represent you in this matter on these dates, and this all work will be done by me, these all documents will be prepared by me, I am providing you with my experience and expertise, my knowledge, so you have to pay me this much of amount of fees. And the client also had to agree to it इधर बाय कंसेंट और इधर बाय द हेल्पलेसनेस कि ठीक है अभी केस लड़ो, इसको हम जीत जाएं, सॉल्व हो जाए मैटर, कुछ आगे प्रोग्रेस हो तब हम देंगे, ठीक है. सो दैट for fees agreement can be made. 1879 Legal Practitioners Act repealed means whatever the earlier legislations were, that was taken back. Repeal मतलब वो वापस ले लिया गया, अब वो खत्म हो गया. It was deemed as if there was no such act. And what was the act which was repealed? Pleaders, Muhtars and Revenue Agents Act. During this time in British India there were 6 grades of practitioners, means 6 level the: advocates, solicitors, vakils of high court and pleaders, mukhtas and revenue agents in the lower courts. Okay, so these are the 6 grades in the lower courts. Vakils became a distinct grade above the pleader. They are above the pleader. So अब ये समझा गया कि एक अलग सी हाई लेवल की पोस्ट है. The act brought all 6 grades into one system. So whatever the 6 systems were divided under this act, by repealing of the act, all these 6 were brought into one place. So 1923 barristers had come to occupy a predominant position in the legal profession. Predominant means something which has a substantial value or which can dominate. The Government of India in 1923 appointed Indian Bar Committee, popularly known as the Chamier Committee, to address the existing disparities in the legal profession, means inconsistencies or the points of difference or differentiation, distinction which was made between the nationality of people or religion or the qualification or the enrollment of advocates or pleaders in a particular court. They will not be allowed to plead in any other court. So all such kind of disparities which were prevalent, to deal with it or to do away with it, this committee was established. It was chaired by Sir Edward, a retired Chief Justice of Patna High Court. The committee in its report stated that it was not practical at that time to organize bar on all India basis. So considering the socio-economic or prevalent conditions of that era, it was not practical and possible that a bar council of India or something on a national or central level could be organized. However, the committee suggested the establishment of bar council for each high court. The committee suggested that a bar council should have power to make rules in matters of qualification, admission of person to be advocates of the concerned high court. Now, since there will be a bar council for each high court, so the advocates or the persons to be admitted as advocate in that particular high court, what could be the minimum or eligible qualifications or admission procedure, all that could be described by that particular bar council related to that particular high court. Legal education, discipline, professional conduct, terms on which advocates of another high court could appear occasionally, means on certain occasions if they are called for, or if their suggestion is seeked, or if there is a party which is concerned to or which is coming under the jurisdiction of दैट पर्टिकुलर हाई कोर्ट. तो फिर उस हाई कोर्ट के सपोज हो सकता है कि कुछ उड़ीसा का कल्चर हमें पता करना है, जिसके लिए उड़ीसा हाई कोर्ट का जो भी वकील है हमें उसकी मदद चाहिए. सो लाइक दैट ओकेजनली ऑन सर्टेन ओकेजन्स दे कैन बी appointed or called for, or any other matter prescribed by the high court. So all the matters related to that particular high court, they would have the power to make rules on that. 1926 giving effect to means implementing the committee's recommendations. Central legislature enacted Indian Bar Council Act 1926. The act was to provide for constitution, that means to make. इनकॉर्पोरेशन का मतलब है कि उसको इनकॉर्पोरेट करना, उसके अंदर इंक्लूड करना, राइट. तो बनाना और इंक्लूड करना. Of bar councils, to confer powers and impose duties on bar council, and to consolidate means to complete or to bring it all together. the regulations pertaining to the legal profession. So the power and duty would be on the bar council, that it would make the regulations and also combine or bring all the regulations together which are related anyway to the legal profession. The bar councils could, with consent of High Court, make rules for rights and duties of advocates and professional conduct. What could be their conduct? How will they said to be a man of proper character and a man of prestige और अ हायर क्लास ऑफ एडवोकेट्स में भी सीनियर एडवोकेट्स होते हैं ना, सुना होगा आपने. तो कैसे आप उनको सीनियर बोलोगे? जस्ट बाय द एक्सपीरियंस और नॉलेज they have, or by the work that they have imparted, by the conduct that they have shown in the court, right? Legal education and examinations. The act eliminated the two grades of practitioners, vakils and pleaders, by merging them in the class of advocates. Now vakils and pleaders को जो 6 grades थे उसमें से ये 2 grades हटा दिए और इसको advocate में ही merge किया. मतलब now the advocates would include these 2 grades who were entitled as of right to practice in high court. Means they were given the right. Entitled as of right means it was their right to practice in the high court in which they were enrolled, and in any other court in British India, subject to certain exceptions like the language restraint that we did earlier also. High courts occupied considerable influence in these matters, and Legal Practitioners Act remained intact. Means it remained as it is was. Pleaders, mukhtas who were practicing in mofussil courts remained out of the scope of the act. Now, classification of lawyers I will be doing with the 2023 edition of the legal education book. And the reason for me picking up this history from the older version was so that you have a holistic and detailed view of the history, which is important to know about the subject which you are studying or dealing with, right? So it is a very detailed explanation which is given in this book. I don't know why they edited out all this, but whatever may be the reasons, government knows better. Apart from that, if you want a thorough history, you should refer to this book. And even for the classification of lawyers, that is the next topic over here, that is also provided in much detail in this book. This is a detailed version, and if you are short of any matter for your answer writing practice or something like that, you can refer to this older version of book which has a detailed concept in comparison to the 2023 edition, which PDF I'm having, and with which I will be beginning off the next topic in the next video. So thank you so much.